This episode is brought to you by Choiceology, an original podcast from Charles Schwab. Hosted by Katie Milkman, an award-winning behavioral scientist and author of the best-selling book, How to Change, Choiceology is a show about the psychology and economics behind our decisions. Hear true stories from Nobel laureates, authors, athletes, and everyday people about why we do the things we do. Listen to Choiceology at schwab.com/podcast or wherever you listen.
Still looking for a natural way to relieve aches and discomfort? Introducing Cornbread Hemp CBD Gummies. Cornbread Hemp CBD Gummies are made to help you feel better, whether it's stress, discomfort, or just needing a little relaxation. They only use the best part of the hemp plant, the flower, for the purest and most potent CBD. Formulated to help relieve discomfort, stress, and sleeplessness. All products are third-party lab-tested and USDA organic to ensure safety and purity. Right now, Amicus listeners can save 30% on their first order. Just head to cornbreadhemp.com/amicus and use code AMICUS at checkout. That's cornbreadhemp.com/amicus and use code AMICUS.
This is Amicus, Slate's podcast about the courts and the law and the Supreme Court. I'm Dahlia Lithwick.
The Voting Rights Act is the birth certificate of our democracy.
Louisiana v. Callais is probably the most important case of the term and surely the most important variable concerning the future of multiracial democracy. It's also one of those really thickety cases that dredges up decades of voting rights precedent, constitutional powers, swirling congressional maps, and so very much law that it can be hard to comprehend the enormity of what is on the chopping block in terms of the Voting Rights Act, and almost equally hard to comprehend the ways in which the Supreme Court, charged with interpreting and enforcing the law as written and precedent as created, plans to eviscerate it. Arguments in Callais took place over almost 3 hours at SCOTUS on Wednesday, and while I doubt many tuned in for all of it, the stagecraft was such that you could be forgiven if you got lost in the pretense that this was all a really hard and thorny new question. This is not a hard and thorny new question. For all the obstruction and occlusion, something important may be about to happen to the Voting Rights Act, and it is our obligation to name it and to explain it and to lay out the stakes. To do that today, I'm joined by Janai Nelson. She's president and director counsel of the NAACP Legal Defense Fund, the nation's premier civil rights law organization fighting for racial justice and equality. LDF was founded in 1940 by legendary civil rights lawyer and the nation's first Black Supreme Court Justice, Thurgood Marshall. Janai is a longtime litigator and a civil rights scholar. She argued Callais at the Supreme Court on Wednesday. Janai Nelson, welcome to Amicus.
Thank you, Dahlia. Happy to be here.
Maybe before we table set this case and its twisty path to oral argument on Wednesday, and the even twistier path the majority appeared to kind of want to take to reach the conclusion it wants to get to, I do want to do some stake setting. It is just not usually the head of the NAACP Legal Defense Fund who argues cases before the Supreme Court. And I wonder if, as you and your team made the decision that you would personally argue this case, what were you thinking about the stakes of what is happening in this litigation in your own mind?
That is such an excellent question. You are right. I happen to have a legacy of former presidents and directors' counsels who have argued before the Supreme Court. So this was not a total aberration. But you're right, it is a rare thing. And to be honest, I have not argued in a court. I did a small hearing virtually during COVID, but I haven't argued in a decade because that's what I leave to the rest of my brilliant and extraordinary legal team. But this case, as you said, is so important. It is such a pivotal moment potentially for our multiracial democracy that I felt it was necessary for us to commit every possible resource to this fight. And that included, me being part of it. And the team that led this case up until this point has just been extraordinary and helped to prepare me for the oral argument. And our co-counsel, we worked with the ACLU on this case as well. And I have to credit my good and dear friend, Anthony Romero, for the suggestion that I argue the case. And I'll know in a matter of weeks whether I should thank him or or not for the suggestion. But no, in all seriousness, I'm very grateful that I did it. And I think it carries on an important legacy for our institution. But most importantly, it mattered to me because this is such a consequential moment for all of us.
Janai, I always feel this way about covering voting rights cases, but I particularly felt it listening to Wednesday's arguments that explaining the Constitution and the statute and the record about redistricting becomes so complicated that once readers or listeners get through all the paragraphs laying out the groundwork, it's just very, very hard to hone in on what the actual fight is that's about to happen or why it's happening. And one of the things that is so dispiriting about this particular case is that the U.S. Supreme Court heard the last version of it just last term. And they held it over on the last day of the term, and they said, come back in the fall. We have new questions we want y'all to answer. But it's not just that. They also heard this case's first cousin, that was Allen v. Milligan, just in the last few years. So no matter what they tried to say on Wednesday, this is just not new. This is something the court has reaffirmed and reaffirmed. And I wonder if we could just start by having you remind us the long path of this particular lawsuit that we can trace back to 2022 when the state of Louisiana draws new maps after the census, and how it is that we wind up at the Supreme Court this very week.
Yes, it is certainly a windy path. We started this case a few years ago, as you said, right after the census was issued, which happens every decade. New numbers come out about our population across the country, and states get to work on redrawing their district lines for Congress, for state legislatures, for school boards, city councils, all of it. We have to do this every 10 years to make sure that we are complying with the principle that most districts have to have the same number of people in them to be fair. So every time the population changes, a new district has to be drawn. That's just the baseline. And so as we were looking at population shifts across the country, we saw that the Black population in Louisiana was creeping up and the white population was continuing to precipitously decline. And Louisiana has 6 congressional districts. And at the time, there was only one that Black people could determine the outcome of in most instances. And 1 out of 6 is not quite reflective of the population breakdown in Louisiana. Black people comprise about 1/3 of the population, and the white electorate is around 58%. And so that alone told us that we should do a deeper dive. We are also very familiar with Louisiana's long history of racial discrimination, its current discrimination on a number of levels, and we have clients there who made it very clear that they believed they have enough numbers and were living closely enough to one another that they could form a second district where Black people might be able to determine the outcome. And so we set about working with them, and they expressed their concerns to the legislature. The legislature gave several reasons over the course of time about, what their aims were. They said they wanted equal districts. They wanted to have the most compact districts. They wanted to make sure that there were very few splits of precincts in the process. And each time we said, okay, if that's what you want, then let us get our experts on it and draw a map that meets those criteria. And every single time that we met those criteria and included a second district that Black people could control, they gave us a different reason for not wanting that map. And so it became apparent that it was not about the criteria, it was about the people. It was not at all about what they professed to be their most significant concerns, the biggest concern was ensuring that Black people did not have a second majority district. And so we brought a lawsuit. And we brought a lot of evidence, 21 witnesses, a 5-day hearing, thousands of pages and many experts. And a district court issued a 152-page decision laying out all the reasons why she thought we were likely to succeed if we continued. We brought this as a injunction case because we wanted to stop the map from going into effect immediately. So we brought a preliminary injunction, we won it, and that was then appealed. And 2 different panels of the Fifth Circuit agreed with us and said, yeah, you are likely to succeed if you continue to prosecute this claim. And so finally, the state of Louisiana, this is after the 2022 elections where that discriminatory map was actually used. Finally, we got relief. And in 2024, after the state drew a new map with a second Black majority district, the elections occurred. They elected Representative Cleo Fields, who's the second Black representative in Louisiana. And that, we thought, at least we hoped, would be the end of the story. But unfortunately, soon after that, a group of white plaintiffs brought a lawsuit and said, in fact, they brought it before the election, they brought a lawsuit and said that they thought it was a discrimination against them to have this map with a second Black district. These are voters who live in that new second Black majority district. And so that is the case that was actually before the Supreme Court. It was an appeal from a decision from a 3-judge panel that determined that, yes, those white voters who brought this lawsuit were in fact discriminated against. There was a racial gerrymander. That's how they described the map that we believed remedied the initial discrimination. And this is an appeal from that lower court's decision. It was a 2-1 decision. And we argued it. It went straight to the Supreme Court, which is what happens in certain voting rights cases. It went from that 3-judge panel to the Supreme Court, and we argued it in March. And my colleague, Stuart Nafee, did a superb job before the court. And we were waiting in June to get an answer. And instead, we got an order to re-argue it this October. And we were quite surprised and obviously somewhat dismayed because we thought we had laid it all on the table in March and given them everything they needed to rule in our favor. And yet they had questions. And they pointed to some specific parts of the case that they wanted to discuss, which I'm sure we'll be discussing too.
Yeah, and I think it's probably worth laying out because we're going to talk about the case law and the precedent. But I thought before we do that, can we just start with the sort of guts of the thing? There's so many ways if you want to kind of go after the precedent and the constitutional protections, go after the statute. There's so much here that you could just flip on its head. If you really wanted to kill Section 2 of the Voting Rights Act without anybody understanding what's happening, there's so many pieces you could just flip. The guts of it is the 14th and 15th Amendment and the Voting Rights Act and the requirements of Section 2. Those are actually being flipped on their head as well here. And so I wonder if you can just guide us briefly through the sort of demands of the 14th and 15th Amendments and then what the Voting Rights Act did and what is left of it, which is Section 2, is meant to do.
So the Voting Rights Act of 1965 is anchored in the 14th and 15th Amendments. And the 14th Amendment, as we all know, contains our Equal Protection Clause, which means that everyone is protected equally under the law. And the 15th Amendment is the only part of the Constitution that explicitly talks about race. And it says that no one should be discriminated in voting on account of race. So it's very specific. And the 14th and 15th Amendments are part of the Reconstruction Amendments. The 13th, 14th, and 15th were meant to reboot our country after slavery and to make sure that every person, and primarily Black people, had equal citizenship in this country on every possible front. And the 14th Amendment wasn't sufficient to make sure that there wasn't ongoing discrimination in voting. It took another amendment that was really dedicated to that very specific issue to do that. But as Chief Justice Roberts wrote just a mere 28 months ago in another case that LDF litigated and won before the Supreme Court, Allen versus Milligan, for nearly a century, the 15th Amendment was nothing more than a parchment promise, meaning it was only on paper. It was only in the Constitution, but not something that Black people actually experienced. In fact, they experienced violence and discrimination at the polls in many, many ways. So that's really the foundation of the Voting Rights Act. The Voting Rights Act came about because there was still this ongoing violence up until at least 1965. And there were efforts as part of the civil rights movement to bring about legislation that would enable Black people to really vote and enjoy the promises of the Constitution. So the Voting Rights Act of 1965 brings in some of the case law that had been developing up until that point and really creates specific rights. There was Section 5 that made sure that any new voting practices or procedures had to be vetted by a federal court or by the Department of Justice before they could go into effect in certain areas, because those areas had a strong history of discrimination. And so we wanted to make sure that they weren't going to continue to discriminate and retrogress, bring the country backwards. So that's one element of the Voting Rights Act. Unfortunately, the Supreme Court disabled that part of the Voting Rights Act in 2013 in a case called Shelby County versus Holder. But then there's Section 2. And in that decision of Shelby County versus Holder, the Supreme Court was very clear that, there's still this permanent provision of the Voting Rights Act that is critically important. And nothing that we say in this case, Shelby County, about Section 5 has anything to do with Section 2. And that was, a little bit of solace concerning Section 2. But unfortunately, just a few years later, there was a decision in a case called Brnovich, and we saw the court come after the remaining provision of the Voting Rights Act that we think is so important, Section 2, and in a decision that was written by Justice Alito, Section 2 was narrowed quite substantially as it pertains to, ways to vote and laws around who gets to vote and what access they have. So that decision came out in 2021. And the other part of Section 2 that remained untouched was the part that really pertains to redistricting. And as part of this whole slew of cases around voting, there was another case, Rucho versus Common Cause, that held that partisan gerrymandering was not justiciable, meaning the court felt that this was a political matter. Parties are going to party. They're going to be partisan, and they're going to divide maps and lines and people in ways that will advantage them. And so the court can't really do much about it. So that was another way in which the case law became narrowed. So all we really had to protect all voters from, manipulation of our districting lines on the basis of race was Section 2 and is Section 2. That's still, it's still the force of law. It's still what we rely on. But this case really calls into question how strong it will continue to be, and frankly, if it will continue to be the protection that we need.
Let's pause to hear from some of our sponsors. This episode is brought to you by Choiceology, an original podcast from Charles Schwab. Choiceology is a show all about the psychology and economics behind our decisions. Each episode shares the latest research in behavioral science and dives into themes like, can we learn to make smarter decisions, and the power of do-overs. The show is hosted by Katie Milkman. She's an award-winning behavioral scientist, professor at the Wharton School, and author of the best-selling book, How to Change. In each episode, Katie talks to authors, historians, athletes, Nobel laureates, and everyday people about why we make irrational choices and how we can make better ones to avoid costly mistakes. Listen and subscribe at schwab.com/podcast or find it wherever you listen. This podcast is brought to you by Progressive Insurance. You chose to hit play on this podcast today. Smart choice. Progressive loves to help people make smart choices. That's why they offer a tool called Auto Quote Explorer that allows you to compare your Progressive car insurance quote with rates from other companies. So you save time on the research and you can enjoy savings when you choose the best rate for you. Give it a try after this episode at Progressive.com. Progressive Casualty Insurance Company and Affiliates. Not available in all states or situations. Prices vary based on how you buy. Time for some life talk. Life insurance talk, that is. You probably have it, but do you know how much you're paying for it and for how much you're being covered? There's a good chance you may be paying too much for too little. And did you know if you receive life insurance through your job and you're unexpectedly laid off, you could suddenly be covered for nothing? Scary to think about, but simple to get right. So check out SelectQuote today. In as little as 15 minutes, SelectQuote's licensed agents compare policies from top-rated carriers to find you the best fit for your health and your budget. It's important to protect your family and your health, and life insurance can provide that peace of mind. Get the right life insurance for you for less and save more than 50% at selectquote.com/amicus. Save more than 50% on term life insurance at selectquote.com/amicus today to get started. That's selectquote.com/amicus. Returning now to Janai Nelson of the NAACP LDF and our conversation about voting rights. When you described the court holding this over and asking for more briefing, you described it as, the court has some questions. And the question just is kind of a bullet to the heart of Section 2, which is whether the state's intentional creation of a second majority-minority district violates either the 14th Amendment or the 15th Amendment, which bars government from denying or restricting voting rights based on race. So this is the question that is put to you. Does Section 2 violate the directive of a colorblind Section 2? It's very easy to get bogged down in, there's a lot of arguing on the other side about we can go big, we can go small, we can get rid of Section 2 altogether, we can cabin it. But this is a big, big swing. And for a court that tends to kind of do a little bit of nibbling around the edges before they take a big swing, it's hard to see this as anything but the majority on the Roberts court saying, it's time.
Yeah, listen, as I said, I was very dismayed when we initially got the order because I felt the court had everything it needed to do the right thing. That said, I have a hard time understanding how this court can write an opinion 28 months after Allen versus Milligan, which was not just a decision in our favor that, just summarily affirmed what we wanted affirmed. It actually went into quite a bit of detail and answered a number of challenges brought by the state of Alabama at the time to Section 2 of the Voting Rights Act that mirrored much of what Louisiana said in its papers in this court. And so the court already decided a lot of these issues. They challenged the constitutionality of Section 2, which has been decided many times and is on very firm footing constitutionally. So they challenged it and the court said, no, that goes against decades of our precedent. We will not entertain this. They tried to overlay this notion of colorblindness on Section 2. And the court said, no, that's not what this is about. And this is designed specifically and very carefully by Congress to address racial discrimination in voting. So race is part of the calculus. In fact, Chief Justice Roberts said, that's the whole point of the enterprise. The language could not have been stronger. The language could not have been clearer. So it's hard to think about how this court is going to potentially write a decision that would undermine such a formidable one and such a recent one. So I remain hopeful about the outcome of this case. I do. And I do that not just because Obviously, I think we are on the right side of the law, but also from experience. People thought that Allen versus Milligan was dead on arrival. People thought that that case was unwinnable, and we won in a big way. So I am continuing to be very hopeful that the court will do the right thing. And in many ways, this is just an extraordinarily easy case, and they can make it one by just allowing us to continue to move forward with a good map that remedies the discrimination.
It's interesting because Justice Kagan made exactly the point that you just made. Like every single central issue has been dismissed by the court very recently. How is it that we're back here?
You're asking us based on arguments that have been specifically rejected by this court over many decades and 3 years ago.
But it does sort of raise this question about precedent, right? Because, as you said, Allen versus Milligan, almost identical circumstances. But we also had the court kind of openly, Janai, trying to make the iconic 1986 case of Thornburg versus Jingles go away. And so it was amazing to hear this conversation of like, how could we kind of rid ourselves of this pesky precedent, including this really, I think, jarring moment where the Chief Justice was claiming that Milligan, quote, took the existing precedent as a given, and they were only looking at Alabama's challenge. But now, like, we're asking you to revisit precedent. I mean, I would love for you to talk about just the deep oddity as a litigator of having the court sort of say precedent, schmecedent, let's start from scratch and ignore all that, because that very much felt like it embodied some of the questioning.
Yeah, I mean, it was somewhat surreal at the time I was sitting because I had already given my affirmative argument, and there were three opponents on the other side, one representing the state of Louisiana, one representing the plaintiffs who were challenging the state's remedial map, and then another representing the United States government. And they were all talking quite passionately about ways to just dismantle this case limb by limb and get rid of what has, frankly, been the tool to help build this multiracial democracy that so many people take for granted and don't understand how it actually came to be, that this was not just evolution, this was litigation that brought it into existence. And so it was disturbing. And to see justices of the Supreme Court also engaging in that colloquy of how do we just abandon a case from 1986. Thornburg versus Jingles was decided in 1986. It has been enforced with great frequency and rigor in the years since, but not as frequently in the past 10 years, right? So as conditions have improved, we have not been able to succeed in litigation in the same way. And that's, frankly, at the end of the day, what I think the justices want, right? They want progress on racial discrimination in voting, and they want an exacting test that weeds out some of the cases that they don't feel are the strongest ones or that are the best examples of the most intensive racialized politics. So the field has already been narrowed quite significantly through Jingles. There's absolutely nothing wrong with the Jingles test. And Jingles, just for those who don't know, it's a test that is quite remarkable. I think it's some of Congress's very best work. It creates three preconditions. So basically, there's a gauntlet of 3 points of proof that you have to put on before you even get to the main part of your case. So if you want to suggest that there is a group of people who are denied opportunity based on their race in the redistricting context, you have to, one, have a group of people who are sufficiently large, right? It can't just be a group of few people. It has to be a large enough community that they could control the outcome of an election in a single member district. And they have to be compact enough, right? They can't be, dispersed all over the state. They have to be near each other residentially so that a reasonable district can be drawn around them, a reasonably configured district. That's a term of art in the Jingles jurisprudence. That's just the first threshold. The second threshold is that that group that we've now established has to be politically cohesive. So they have to tend to vote in the same way. They all like the same candidates or vote on the same issues. They have to be politically cohesive. And the way to determine that is to conduct all of these statistical analyses about how these folks vote and who they vote for. And you look at voting behavior and patterns over time. So it's a fairly rigorous proof point. And then the final proof point is equally rigorous, and it demonstrates that there's white bloc voting. So if it's a minority group that is saying their vote is being diluted, it's not just diluted because they don't have a district. It's being diluted because white residents in the same state are voting cohesively and together and constantly, or as the test says, usually outvote the other group. And so by virtue of being a minority group, they will never be able to control who represents them if they don't have their own district, right? So it's sort of a matter of fairness and making certain that minority groups aren't perpetually submerged in the political process and have absolutely no agency in who represents them. And that's just the beginning of the test. After you meet those 3 thresholds, then you get to engage in what I think is some of the more interesting parts of the test, and it's called the totality of the circumstances. And there are about, 9 different factors that the courts have pointed to that are relevant. I won't go through all 9 here, but they range from looking at the history of discrimination in the area that the state that you're challenging. They look, for example, at whether candidates of the race of the plaintiffs, the group that's challenging and suggesting there's discrimination, whether any of the candidates from that racial group are able to be elected in that state. And by way of example, Louisiana has never elected a Black person statewide, not ever in its history. Has a Black person won on a statewide basis in Louisiana? So we look at those types of things as indicators of a inhospitable electoral environment. And there are many other factors, but basically, once you've proven those 3 threshold matters, and then you look at the state as a whole and the history and the current discrimination and who's being elected and whether there are different devices and other ways to bring discrimination into the electoral process, that's when you can win a case. And that's everything that we did to prove that Louisiana was discriminating against Black voters.
I first just want to emphasize and amplify something that you just said. There were 3 lawyers arguing on the other side to your 1. And the time spent in arguments was commensurate with that. There was plenty of time for a lot of arguments to be floated on the other side and for the majority to kick around and workshop. I want to have a little bit of a lightning round here to bop through the many ways different conservative justices were openly seeking to minimize the enormity of what is being attempted here. Some of those arguments are actually pretty familiar to us. One of them is the sell-by date argument, right? This is the beloved argument of Justice Kavanaugh.
Race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint.
And in this context, I think you said this when you were being challenged by him, there is nothing that demands a sell-by date, right?
Absolutely. There's no basis in our precedent to suggest that any statute must be dissolved simply because of the passage of time. There's absolutely nothing that says that that must happen. And in fact, I can't really point to any statutes that I'm aware of where the court has taken that action recently. So to single out the Voting Rights Act, which the court has held is the crown jewel of civil rights legislation, is absolutely shocking to think that that's the place where you want to begin to say that statutes must be dissolved. The other reason is that, as we said at the very beginning, the Voting Rights Act is an extension of the 14th and 15th Amendments, right? It's meant to effectuate the mandates in both of those constitutional amendments, and those are permanent rights. So the statute that protects those rights and, gives guidance on how to enforce those rights should also be permanent. Nothing has changed since the court assumed all of the constitutional matters that Alabama raised just, 2 years ago. Nothing has changed in the interim except, some conditions that are external to the court, which should not matter. So I am very concerned that what seems like a pretty innocuous argument of a sell-by date is even being entertained.
Another thing that I'm becoming creepily familiar with is the court sort of poo-pooing congressional intent. And we had a couple of flavors of that this week. One is we can do away with the difference between intent and effect, even though Congress was very explicit with the Voting Rights Act that effect mattered as much as racial intent. And the idea that, we've got, again, this is Justice Kavanaugh more or less saying, look, we don't have to defer to Congress. We're applying the Equal Protection Clause here.
When we're applying the Equal Protection Clause, or as Justice Barrett said, the 15th Amendment, congruent in proportionality, or 14th Amendment, deferring to Congress is, I think, not what we're supposed to do.
This is another version of the court saying it doesn't really matter what Congress explicitly did in the Voting Rights Act. We have some other job that is more important than that. And particularly with respect to this kind of effects versus intent test and the attempt to say, it doesn't matter. We're not going to do the effects test anymore. That Congress's vision of what it was seeking to do is immaterial. It's becoming a familiar trope at the court, but it's quite worrying that the court doesn't think that what Congress wants to do matters.
No, that's exactly right. And as much as Justice Kavanaugh is attracted to this sell-by date argument, he's also someone who is a strong defender of stare decisis and separation of powers. Those are two areas where he has been very vocal in his decisions. And with separation of powers, it actually defeats the whole sell-by date argument as well. When Congress wanted to limit the duration of a part of the Voting Rights Act, it did it. It did it quite explicitly. It did it with Section 5. Section 5 was a part of the Voting Rights Act that had to be reauthorized every several years. And Congress continued to extend the dates and was very clear about the record that was needed to do so. It never suggested that Section 2 should be reauthorized or that it had any end date. And so if anyone's just looking at statutory interpretation, they would know that Section 2 doesn't need an end date. But even if we zoom out just to the broader question about the Voting Rights Act as a whole, Congress could decide at some point that we no longer need the Voting Rights Act, and it hasn't. And so the court should not be the one to override Congress's judgment. That invades separation of powers. So this case raises so many issues of deep concern, not only about the specifics of the case, but about the court's overreach potentially into areas that have historically not been its domain, and for great reason, because we really respect the independence of each institution as a check on one another. And if we start to erode those barriers, we really will be in much more of a constitutional crisis than I think we already are.
We've already run through now a few of the moves floated by some of the conservative justices that are being used in pursuit of this goal, like making precedent go away or disregarding explicit, very comprehensive, voluminous findings from the trial court, or making separation of powers go away, or ignoring Congress and saying simply that it doesn't matter what has come before. The old cases are too old. The new cases are too new. But then there's perhaps, at least in my mind, the most outrageous one, which was given voice by Justice Neil Gorsuch this week, who asked,
is it acceptable under Section 2, as you understand it, given our precedents, for a court to intentionally discriminate in a remedial map on the basis of race?
In other words, we just can't use race for anything anymore, ever, even though it's expressly in the text of the statute and in the 14th and 15th Amendments. So I guess I wondered, among all these moves, is there one that strikes you as the single most alarming in terms of what happens if the court keeps on playing that game?
Ooh, there's so many alarming issues there. But yes, this idea that we are, post-racial, or you cannot use race to remedy what we know is still pretty rampant racial discrimination in many spheres of our society is very concerning as we, continue to be a increasingly diverse, multiracial democracy. That's just no way to prepare for, changing demographics and ensure that we are on a steady course of progress. So, yeah, that is certainly very alarming to me. I will say, though, that there is a misperception that I think even some of the justices might hold in terms of whether Section 2 actually mandates race-based districting. It does not. To be 100% clear, there's nothing in Section 2 that mandates a specific remedy. What Section 2 does is illuminate racial discrimination, and then it's up to states and courts to determine what the best recourse is. And many districting plans have been drawn without significant regard to race that can remedy discrimination. And then there's also alternative remedies. There are remedies like cumulative voting and limited voting that have been employed in contexts where they're viable. So it doesn't work for congressional elections, but for some of the down ballot races and other districting mechanisms, it's perfectly fine. So there's this misperception about the overuse of race in connection with Section 2, and I hope that we were able to clear some of that up during the argument.
We're going to take a short break. This show is brought to you by BetterHelp. Moments in therapy, like the right question, a safe space to cry, or a small win, can change lives. Behind every one of those moments is a therapist who showed up and listened. October 10th is World Mental Health Day, and this year BetterHelp is honoring those connections by making it easy to get guidance from a licensed therapist online. With over 30,000 therapists, BetterHelp is the world's largest online therapy platform. BetterHelp's short questionnaire helps identify your therapy needs and preferences. This World Mental Health Day, we're celebrating the therapists who've helped millions of people take a step forward. If you're ready to find the right therapist for you, BetterHelp can help you start that journey. Our listeners get 10% off their first month at betterhelp.com/amicus. That's BetterHelp, HELP.com/amicus.
This episode is brought to you by Planned Parenthood Federation of America. It's easy to feel powerless when court decisions continue to chip away at what's left of healthcare and reproductive rights. Some lawmakers are trying to end abortion access, slash funding people rely on for care, and shut down Planned Parenthood health centers. These attacks only deepen the healthcare crisis they created, putting millions at risk. But here's the truth. Planned Parenthood isn't going anywhere. Planned Parenthood has remained strong for over a century because of supporters like you. With your commitment, Planned Parenthood can keep defending the care people need, whether it's birth control, cancer screenings, abortion, gender-affirming care, or sex education. Join the fight by donating to support Planned Parenthood today at plannedparenthood.org/defend. Your support ensures care continues for those who need it most, no matter what.
This podcast is brought to you by Progressive Insurance. Do you ever find yourself playing the budgeting game, shifting a little money here, a little there, just hoping it all works out? Well, with the Name Your Price tool from Progressive, you can be a better budgeter and potentially lower your insurance bill, too. You tell Progressive what you want to pay for car insurance, and they'll help you find options within your budget. Try it today at Progressive.com. Progressive Casualty Insurance Company and Affiliates. Price and coverage match limited by state law. Not available in all states.
Let's return now to my conversation with Janai Nelson, President and Director Counsel of the NAACP Legal Defense Fund. as everybody predicted, affirmative action, the SFFA case we talked about in detail with Justin Driver on the show a few weeks ago, reared its head, even though this was not an affirmative action case. Can you explain why that case, in some sense, laid the groundwork and thus really inflected on the conversation here about voting rights?
Yeah, SFFA has been the gift that keeps on giving extremists an excuse to, metastasize that horrible decision in areas where it has absolutely no relevance. And the fight to protect Section 2 is one of them. They tried to suggest that the court is saying that race cannot be used in any circumstance ever, no matter what. And that's absolutely not what SFFA holds. SFFA, as we all know, involved, college admissions. And even in that decision, the court said that race can be used to remedy specific evidence of discrimination, which is what Section 2 unearths. So it is entirely consonant with the goals of Section 2. Also, Section 2 is a remedial statute. In SFFA, the court was, looking at an admissions program that's based on a diversity rationale, which is quite different. The court's concerns about, whether affirmative action, as Harvard and UNC were using it, could be measured. Did it have a logical endpoint? None of that is pertinent in the area of voting because it is an extraordinarily metric-driven test and claim. And the endpoint is when we no longer have racialized politics and housing and residential segregation that would give rise to a Section 2 claim. So it's just an entirely different animal. But of course, people that are hostile to the Voting Rights Act are going to try to use every possible argument. And we've seen SFFA weaponized against DEI. We've seen SFFA weaponized in almost every arena of civil rights, to be frank. And so I'm not surprised that it reared its head here, but it is completely irrelevant in my view. And I'll make one other important point that I did bring up in the argument, and that is the SFFA decision was issued a mere 3 weeks after Allen versus Milligan, which upheld Section 2 of the Voting Rights Act very robustly. So I've got to believe that in a decision that Chief Justice Roberts wrote 3 weeks apart from one another, that he knew what he was doing and he wasn't overruling himself in 3 weeks. He understood that these two decisions were reconcilable and one did not cancel out the other. So that argument to me is, it doesn't hold water.
Janai, I can't let you go without asking you to just lay out the stakes. Because as I said at the beginning, I think that's not always clear. And you described it, if there's no functioning Section 2, at argument, you said the consequences, quote, would be pretty catastrophic. Can you just lay out what happens if Section 2 is either clawed way back or gone altogether going forward, particularly for folks who are looking down the barrel of midterms very soon?
Yeah, I stand by that characterization. It would be catastrophic if we lose Section 2. And Louisiana provides a perfect example of how it would be. The only way that we even had one majority Black district in the state that has the second highest percentage of Black people in the country is because we fought for it and litigated and won it under Section 2. And we're debating whether a second majority minority district should be added in Louisiana. I can tell you that without Section 2, there would be none. So we wouldn't be talking about a map of, 5-1 or 4-2. We'd be talking about a 6-0 map, meaning Black people, even though they represent 33% of the state, would have 0 congressional districts in which they could determine the outcome. And that's a microcosm of what would be happening across the country. State legislatures would manipulate voters on the basis of race for partisan efforts or just because they are engaging in racial discrimination outright, and we would have very little recourse. The Constitution is still there, but we know, based on over a century of use of the Constitution in ways that were ultimately feckless, we needed the Voting Rights Act to actually animate the principles of the 14th and 15th Amendment. So without Section 2, we would be back to a right on paper only, and that's not a circumstance this country can afford.
Janai, can I ask you to close by answering the question we ask a lot of our guests here, which is, and I want to stipulate it is not your job to predict the future. I'm not going to ask you to, but I would love for you to pan back and give me your sort of broadest thoughts on this moment that we're in, because there is a sense in which us fretting about redistricting in the near term seems very quaint when, the U.S. military is like overtaking cities in peacetime and, masked secret police are dragging people through the streets. And, we're using the shutdown as an opportunity to gut institutions that you and I know are a bulwark for democracy. And on this show, I think we spent a lot of time trying to pick our way between the law doesn't matter and the law is going to save us. The courts are going to save us. And both of those, I think, are dangerous extremes. And I think, Janai, that there's no organization that is better at picking a path through those two nihilist extremes than LDF. You've always been the pathfinders in terms of finding a way to triangulate against the sort of hopelessness of it has ever been thus and the courts can't help us, or, the courts are made of magic and they always do the right thing. I would love for you to tell me how you at LDF, but also how you, as somebody who's been thinking about the law and the courts for a really long time, are locating yourself in this very broad, very depressing conversation about the role of the law as democracy feels like it's awfully wobbly.
Yeah. I think that I have had to continue to hope that our system is not so fundamentally broken that in a time of crisis, our most important institutions will not rise to the occasion. I also understand the arc of history well enough to know that that is not a foregone conclusion and that we have been disappointed many, many times. I would like to believe that we've all learned lessons from history and recognize the threat that this moment holds, and that this is no time to dismantle the protections that have, held us, carried us forward, enabled us to progress. And I mean that for Section 2. I mean that for the Voting Rights Act writ large. And I also mean that for jurisprudential theories like stare decisis and separation of powers and, constitutional avoidance and all of the theories and things that have made us a very, I think, emblematic constitutional democracy in so many ways. We are far from perfect. And I would like to believe that our courts are not done with the job of trying to continue to perfect us. And I'll just say the right to vote is so important to everything that we are experiencing right now. If we think that we still want to solve problems in a nonviolent way through processes and to use our democratic system as the space to resolve conflict, if we believe in that, then we must protect the right to vote. It is the currency that we all hold in equal measure. And, to use the words of the Supreme Court itself in 1964, in a case called Westbury versus Sanders, the Supreme Court said no right is more precious in a free country than that of having a voice in the election of those who make the laws under which as good citizens we must live. Other rights, even the most basic, are illusory if the right to vote is undermined. And that's really what this is about. If we don't have a right to vote that is free from dilution and discrimination, then we have no vehicle to exercise all of our other rights and to vindicate and protect all of our other rights. So this is a fight for absolutely everyone. And I am hopeful that we will win it.
And perhaps a fight also for absolutely everything. I'm mindful that on last week's show, we talked about the military on the streets and the intrinsic connection between that and voting, and how it always comes back to voting. And these hyper-technical cases are everything in some sense. Janai, you've taken us through an entire voting rights class in less than an hour. Is there anything that you want to say for folks who are really, really trying to understand an immense amount of material that they know is important, but they're not entirely sure how this is going to go?
So I don't think many Americans pay much attention to the role that the Voting Rights Act has played in shaping, forming, protecting, advancing our democracy. And many people, because it arose from the civil rights movement, believe that it's a law that, just protects certain types of people and it's really not their business. The Voting Rights Act is the birth certificate of our democracy. And I feel that this case is of extraordinary importance to every single American who cares about how the court rules, whether it respects its own precedent, and importantly, how it treats this critical law that I believe is, the stitching on the fabric of our democracy.
Thank you so very much, Janai Nelson, both for taking a little time with us, but also for the exceptional work that you have done, you will continue to do to help us become the democracy we are meant to be. Thank you.
Thank you, Dahlia. Always great talking to you.
Janai Nelson is president and director counsel of the NAACP Legal Defense Fund. She is a longtime litigator, she's a civil rights scholar, and she argued Callais at the Supreme Court on Wednesday. That's all for this episode. Thank you so much for listening, and thank you so much for your letters and your questions. Keep them coming. We are reachable by email at amicus@slate.com. You can find us at facebook.com/amicus-podcast. You can also leave a comment if you're listening on Spotify or on YouTube, or rate us and review us on Apple Podcasts. On today's Amicus Plus bonus episode, Mark Joseph Stern and I are talking about a whole slew of really significant decisions we've had in the lower courts this week on FEMA grants and on Trump's firing of federal workers. And we're also wondering if there was any way around the worrying precedent set by greenlighting the administration's wildly illegal cash grab to pay the troops in the shutdown. You can subscribe to Slate Plus directly from the Amicus show page on Apple Podcasts and Spotify, or visit slate.com/Amicus Plus to get access wherever you listen. That episode is available for you to listen to right now. We'll see you there. Sarah Birmingham is Amicus's senior producer. Our producer is Patrick Fort. Hillary Fry is Slate's editor-in-chief. Susan Matthews is executive editor. Mia Lobel is executive producer of Slate Podcasts. And Ben Richmond is our senior director of operations. We'll be back with another episode of Amicus next week.
Rinse takes your laundry and hand-delivers it to your door, expertly cleaned and folded, so you could take the time once spent folding and sorting and waiting to finally pursue a whole new version of you. Like Tea Time You. Or this Tea Time You. Or even this Tea Time You.
So did you hear about Dave?
Or even Tea Time You.
So update on Dave.
It's up to you. We'll take the laundry. Rinse. It's time to be great.